Tom Sackville, who was the junior minister at the time in 1996, brought forward a white paper and said, in Tom's words, the government is determined to do this in a way in which minimises the burden on business and other users. And so you can quite clearly see a track record over a period of time from successive governments of wanting to reduce burden on business. And if we go to the next slide, Emma, this was consistent when we consider the 2018 Act. The 2018 Act was sponsored by, at the time, the Department of Culture, Media and Sport, who was Matt Hancock. But once again, we can see that Matt Hancock's language and bringing forward statements to say, actually, what we want to do is reduce the regulatory burden. So why do we find ourselves now in a position in 2022 that we've all of a sudden got a new data protection act and data protection bill coming forward and an act which will follow? Well, one could say that the evidence exists that governments consistently have since 1984 introduced legislation which is a balance between the rights of the data subject and also the burden. And there is certainly a view brought forward by the Minister of defining Brexit benefits before the last reshuffle as such. Jacobs Rees-Mogg was that Jacobs Rees-Mogg put in the list of Brexit benefits the opportunity to reduce the regulatory burden formed by GDPR. So there is a clear pathway there, which has started since 1984, that governments see data protection regulation as a burden on data controllers. It's a balance with the rights of data subjects, but of course, there is this challenge of it is seen as a regulatory burden. So one could conjecture, and this is my own personal view, that the burden is predominantly seen as something which will hinder the growth strategy. And the growth strategy is quite interesting because there have been two other further developments in the last couple of weeks that you may have seen from the new government, one of which is a fiscal financial statement next week from the Treasury, which is about unleashing and also creating growth. And also there was a statement this morning predominantly around reducing the burden on retailers, particularly around the obesity strategy in the UK. So we could see this as part of a broader agenda to have A, legislation made in London, and B, reduce the burden further on UK businesses. What else do we see the context behind the changes that may sit in here? If we go to the next slide, please, Emma. Well, the 2018 Data Protection Act was enacted fairly quickly. And the reason why it was enacted fairly quickly was after the decision that the UK made to leave the European Union, there was clearly a number of activities that needed to take place. However, whilst the General Data Protection Regulation was a regulation per se, i.e. it did not lead UK enabling legislation, what we did find is that we had the Law Enforcement Directive and also the Intelligence Services Directive from the European Union, which had to have enabling legislation within the UK. So the 2018 Data Protection Act was seen as the right vehicle for that. And as a result of that, that's why the GDPR is referenced in the Data Protection Act. And whilst the Law Enforcement Intelligence Services Directive are not only referenced, but clearly detailed within the Act. So it was done fairly quickly to meet the deadline of the 25th of May, 2018. The other thing that I think I'll say in context is a lot of people get very excited about adequacy. Well, in simple terms, our adequacy arrangement with the European Union and every other adequacy arrangement requires mainly three things: that the country that you're exporting data into has one, human rights legislation, two, data protection legislation, two, that it has a regulator, in our case, the Information Commissioner, and three, there is redress through the courts to be able to redress any remedy as a result of one, human rights, or B, data protection legislation breaches. And Jersey, the Isle of Man, and Switzerland are two good examples where the law is not identical to GDPR, but they're able to meet the criteria of adequacy on the basis of they fulfill the requirement of, one, having judicial recourse, two, they have a regulator, and three, they have human rights, and they also have data protection legislation. Now, for my own view, and this is my own contextual view, there are a number of changes contained in the current Data Protection and Digital Information Bill, which I think could have been made through guidance, certainly under the current GDPR Article 23, which allows each individual country in the past, member state, we're not a member state anymore in the UK, to make their own arrangements to that. So those could have been done, but they weren't. And I also think there is a challenge for organizations which, for example, process the personal data of those people in Berlin or Paris or Madrid or Johannesburg or Delhi or Singapore or Beijing. There is still a requirement to meet, in the case of European countries, GDPR, and also in the case of other legislation, the local legislation that exists. So you could find that the challenge of the Data Protection and Digital Information Act might be great for UK companies where you're only processing personal data of those people based within the United Kingdom, but the minute you process personal data of those without the United Kingdom, you might have a challenge relative to maintaining and requiring to maintain the local laws. And if it's a European country who reside in the European Union, it'll be GDPR. So that's the context, setting the context. And we're now going to get stuck into the real detail here. And we're going to just look at the principles of lawful basis. And what I would like to do is I'd like to ask Cumby really to bring forward this slide, and then Emily and Andrew will add their piece just after Cumby. So Cumby, what does the bill say about the principles and lawful basis for processing?
Thank you very much, Nigel. So with regard to the lawful basis for processing, the position under the GDPR and the status quo is that you have to identify one of the lawful bases contained in the legislation in order to be able to process data. And if that data is special category data, you have to find an additional basis that would make it lawful for you to process that data. Now, what the Data Protection and Digital Information Bill is seeking to do is simplify the process through which organizations are able to identify and adopt one of those lawful bases in order to be able to process personal data. Now, as Nigel mentioned, one of the driving factors behind the bill is a desire to see UK businesses be able to utilize data for innovation, economic activity, without also losing the rights that citizens have, that residents and people, generally speaking, that the bill applies to have. Now, the first way the bill is trying to achieve that is changing the definition of personal data. Now, under the GDPR, personal data includes data even if it's not directly tied to an individual, insofar as the possibility exists that information can be used to identify an individual using additional information. Now, the approach that the bill is taking is reducing the threshold of identifiability. Now, it then says that personal data will not be considered to be personal data unless there's a reasonable possibility that can be reasonably foreseen that the organization processing that data will have access to the necessary additional information to link it to the individual. Now, the import of this from an economic perspective is that organizations are going to be able to pseudonymize data and then use that data for things like research, which is a huge focus in the bill. Actually, it runs through the entirety of the bill, trying to facilitate research and innovation and scientific developments, such that organizations will be able to use pseudonymous data that doesn't directly identify someone, even though under the old GDPR, that data will still be subject to all the rules and regulations contained in the law. So
no, could be good. Very interesting point. Is there a definition anywhere in the bill of reasonable?
No, there's no definition specifically. It just says that it's going to be data that the organization can reasonably foresee that it would be able to, merge with other information to identify an individual. So it's going to boil down to judicial interpretation at the end of the day, or guidance from the ICO. Ultimately,
because at the moment, Kumbi, the guidance from the ICO is quite clear about the fact is that personal data is anything that can identify indirectly or directly an individual, but the ICO guidance is very clear about the fact is that you need the capability to be able to do that. So, whilst, for an example, the everyday man and woman in the street necessarily wouldn't have the tools and equipment to work out an IP address, there are some organizations which will be able to identify an individual back to an IP address, for an example. So there are no clear definitions in what reasonable might look like then. Yeah,
so ultimately the keyword is likely to be identified. Now, because the implication is that even if that capability exists, is it likely to occur, in the sense that even if an ISP has the information that would tie an IP address to an individual's name and their home address and all other information about them, the likelihood of that taking place is what the organization by itself has to take into consideration in determining whether it will treat that data as personal data or as pseudonymized or anonymous data that doesn't fall within the ambit of the law. Now, crucially, the approach the bill takes is a risk-based approach. So much of what runs through the bill is leaving the determination of some of these things in the hands of the organizations that are processing data. So an organization that makes the decision that a data set is anonymous and doesn't need to be treated as personal data will have to answer to the ICO in the event that what it had claimed was unlikely eventually takes place, right? So ultimately, the risk-based approach is what the bill is asking organizations to take. They have to make a decision about likelihood. Yes.
Can I just ask our other legal experts on the line? Emily, what's your, because clearly the definition of personal data is what makes our, makes our daily life the first test. The first test that any practitioner should do is it personal data? Emily, what's your thoughts on the personal data issue? I sound like Durant here. What's your thoughts on the proposed changes to the personal data issue?
So it seems to me then that it's changing very much to a sort of a subjective view of reasonably likely to identify. So would the person who's dealing with, for example, the the consideration of whether it's personal data or not, are they reasonably likely to think, okay, well, someone can be identified from this data that I'm looking at, and so therefore I will classify it as personal data. So it's certainly a divergence away, if this is the suggestion, and it's true that it needs much more clarification as to exactly what it is as practitioners that we're supposed to be advising people, the approach to take and how to sort of establish whether or not it's personal data. But it's certainly a divergence away from the sort of the EU system that we're going to see, I think.
Yeah, I've got a question for Victoria in a minute, but Andrew, what are your thoughts on this? This is very interesting, isn't it? So.
Yeah, it's quite interesting. I think so. My counting of the word reasonably and reasonable within the confines of the 192 page document is that it's mentioned 102 times. And interestingly, I mean, the lawyers amongst us would be able to say, oh, well, we can look at good old Wednesbury for inspiration in setting out what reasonable is. And, for those of us that are not lawyers on the call, Wednesbury obviously sets the rather draconian sort of concept of reasonableness, but being that would any reasonably minded person consider it to be unreasonable is probably a good way to surmise. So ultimately, it is strange that the definition is moving insofar as pseudonymized data is not necessarily going to be a means of personal data. So I think there's actually going to be a bit of confusion, particularly for more international organizations where they're probably going to have pretty competing legislative and regulatory obligations to adhere to. And so I think for many, this change in definition might actually have little or no use to them, because it would be virtually impossible to manage or to implement. So yeah, quite interesting.
I could see a point, just thinking about this sort of right off the top of my head. I can see a point whereby, and Teresa and Victoria have got a couple of questions, so I'll put them to the team shortly. But I can see a point whereby, for example, if you're internally processing pseudonymizing information and you can only access them internally by the software you're using, then clearly if it's an internal process, then does it become personal data? Because the activity to unpack that pseudonymization can only be achieved with the bespoke software that the organization has. So therefore it's not personal data to others, but to that organization it may be. So I can see you make a point. Now, Teresa asked the question, would it be necessary to document the decisions of whether a data set is personal data or not? Yes, Teresa, the accountability obligations currently under Article 5.2, whereby the controller has to demonstrate compliance, would still exist. And I think that you would want to clearly identify your decision and your process. So the answer would be yes, the compliance regime would still exist. Victoria asked the question from the, does likely to receive include considerations of motivated intruders and data breaches? That's interesting. Yes, that's actually very good, isn't it? Yeah, I like that.
Do you want me to give it a go?
Yes, go on.
Yes, I would say on one hand, no. I would say that in the strict interpretation of that clause, the way it was drafted, it's referring to organizations to which you might likely transfer that data. But in practical terms, if you are dealing with the compliance of an organization, you would have a responsibility to consider all the possible ways in which that data might be accessed and potentially combined with other data to identify individuals. So strictly speaking, if you look at it from a strictly legal perspective, no, it's likely to receive. The use of recipients in the Act has consistently referred to people and organizations to which an organization chooses to transfer personal data. But from a practical standpoint, you would be wise to consider all possible ways in which that data might be accessed by any party, whether they're doing so bona fide or in bad faith or as a hack or breach or however else. Yeah,
so in answer to your question, Victoria, most probably, yes. I think, yeah. I think it's a lot of things, and I mentioned Durrant there just now, my expertise in subject access requests, and I spent a lot of time studying Durrant. It wasn't until you have a seminal case where someone brings forward a case whereby you have a definition of these sort of things. And Andrew mentioned reasonableness, and we always remember from, I'm ancient, and I remember from my initial legal training, the reasonable man and woman on top of the Clapham omnibus from Lord Denning. I'm that old, by the way. Emily, we've got a question from Shirley. Shirley has said, are there factors that an organisation must look out for in deciding likelihood? That's good, isn't it? Yeah.
I would say yes. I suppose that goes back to the subjective point. So it's probably a lot to do with the sort of circumstances and understanding sort of what personal data you have and why and what it relates to and the exact nature of the personal data. So it might be, for example, the sensitivity, so the type of data. It's difficult to kind of put it in context, but I suppose if we were looking at it in sort of a wider situation, perhaps of a subject access request being made, then you would understand, kind of that gives you some context in terms of the nature of the personal data and how it relates to that individual, the data subject.
Yeah, cool. And Andrew, does then the definition of personal data then blend itself nicely to a risk-based approach?
Define risk-based approach. I think this is the problem. Risk is incredibly subjective, so much so that the ISO 31000 standard is not a certification, it's a process of guidance. So risk is very determinant upon the business risk-based approach to risk. So I'm a bit dubious in terms of what's actually meant by risk-based approach. I do think that there's further guidelines and required here, because I do think that with the subjectivity that comes with this, it can fall into a number of bad or perhaps not best practice in terms of assessing and evaluating risk of personal data. So I do think there's definitely room for improvement on this one. And certainly when I hear risk-based approach, my experience of international organizations over the years have been that everybody's risk appetite is very different, and that usually filters through the convergence of compliance and legal as a whole. So I think for me, the jury is still very much out.
Cool. Thank you, Andrew. Could you just cover the other 2 points reasonably quickly, and then we'll move on to data subject rights. That would be helpful. Thank you.
Certainly. So in furtherance of the goal of trying to make it easier for organizations to select legitimate interest, to select lawful basis upon which they can process data, and also upon which they can further process data after they have collected and utilized it for the original purpose. I'm combining both points now. The bill proposes some sort of safe harbor, activities wherein if the data has been processed for those activities, an organization would be able to skip the process where they would need to take a legitimate interest assessment, for instance, in order to be able to determine that they can process that data for that purpose. Now, legitimate interest assessment is a priority in the bill because that's the most commonly used lawful basis upon which organizations process data. So the ones that have been identified as being these categories that organizations can, in quote, automatically process data on are things like national security, emergencies, crime, safeguarding, scientific research, historical research, and emergencies, again, and crime for repurposing of data. So again, it ties in with the goal of trying to streamline the process for organizations that are conducting processing activities that the government has deemed to be, 1, low risk, and 2, very crucial for economic development. So on one hand, you have the public security, emergencies, and crime, and on the other hand, you have scientific and historical research that the government considers to be crucial for boosting the economy.
No, that's very interesting, because Andrew, then Emily, and to me that sounds like giving the ability of organizations, particularly public sector organizations, to be able to steamroller individual rights and just do it because they've done a legitimate interest assessment. Am I wrong, or am I being am I being too data rights focused?
No, I think there's perhaps some truth in that. I think legitimate interest is still one of those very grey areas in law anyway, because ultimately, the lawyers amongst us will know that if a client or an organization wants to rely upon legitimate interest, there's usually a process in which you can be able to apply a certain set of standards that will manage to make that lawful basis work for you. Obviously that's subject to levels of independence and accountability, which are separate in many respects, but ultimately all feed into the same thing. What I'm trying to say is legitimate interest, I think, is actually quite a difficult lawful basis to rely on anyway. And I think organizations should be looking at it as a last resort. There are other ample lawful bases that exist within the law that organizations should, and where possible, rely on. Consent, I know, obviously has a very, very high threshold, but if you comply with the conditions of consent, then you will ultimately have a very strong lawful basis. Legitimate interest is not without challenge, and therefore people must remember that organisations that are relying upon legitimate interest are not without the ability to be subject to challenge. In the current framework, legitimate interest assessments are not compulsory, but they are recommended so that you can comply with your accountability measures. That's really important, because ultimately, if you try to challenge an organisation on its reliance on legitimate interest, will they have a legitimate interest assessment in which they would be able to provide a summary of at least a summary of the proportionality, the necessity, and reasonable sort of balancing test that's taken. And I think, in most part, I don't think that exists.
Emily, what's your view on the proposed changes on legitimate interest? And I guess it's public interest if it's a public sector body, I guess. So, yeah.
Yeah, I mean, I think I'd agree with Andrew. And I mean, suffice to say that, you know, as a public authority, then you would be very much sort of you'd be subject to that level of internal scrutiny and decision making and recording your decision, as Andrew said. So I suspect that will help to sort of establish or justify the extent to which the legitimate interest wants to be relied on.
And I could see some really, Emily, I could see some really interesting points, particularly around healthcare. You know, the recent debate about sharing data across healthcare organisations. Now, I know the facility already exists of that, but you know, I could see that. But certainly, law enforcement data, those sort of things, without safeguard. You know, I think there will be safeguards, but clearly, the strength of those safeguards will be quite interesting. So, Emily, what do you think about the quote here from Marie, which I think is very good? Again, a question of definition. One person's legitimacy is another person's gross infringement.
Well, isn't that exactly the problem? Yes, that's quite right. Yeah, so it's very much a balance, isn't it, between you know, making the system. Yeah, because I suppose that's the main criticism, isn't it, of the bill, insofar as, you know, the idea is to sort of cut through the red tape and make it easier. But at the same time, you know, if everybody's got used to a certain level of protection of data and a certain way of, you know, accountability and things, to then say, well, actually, we're going to make everything much easier, and, you know, so it's much easier to transfer data around, causes concern.
Yes, absolutely.
Yeah, I'd agree.
And I'm smiling because I remember the words of Brian Mulwilly, who was the Home Secretary in 1997. Data protection law used to reside with the Home Secretary, and he said, "We'll do the minimum possible to enact the 1995 EU directive on data protection." So, so one is right to have some hesitancy in saying, actually, it'll be all fine. Okay, so next slide. Thank you, Kumbi. Next slide. I think, Emily, you're going to kick us off on this, aren't you? Data subject rights.
I am, yes, thank you. Proposed changes to data subject rights then under the new bill. So as Nigel says there in the first point, a change of the threshold. So this is something that I've come across a lot in advising clients in relation to dealing with data subject access requests, so DSARs there. So the right to access personal data under Article 15. So the proposal is the change in the threshold. So to change it from as it is at the moment to manifestly unfounded or excessive, to much more one of vexatious or excessive. So sort of to lower the threshold effectively, which from a practical point of view, I think will be hugely helpful. But that's probably because I say it from the part of advising organisations who are dealing with these.
Emily, I know we've got some data protection apprentices on the line. I can see that. So what's the difference between manifestly unfounded? What does that look like, and what does vexatious look like in simple terms?
So I suppose for those non-lawyers of us, so vexatious is a sort of term that we use to in kind of legal, and you often come across it in a litigation context as well. So I guess the plain meaning vexatious, so, you know, an almost kind of determined, sort of almost unnecessary, I guess it brings up ideas of, you know, you're not really interested in accessing your personal data, you're just trying to sort of cause a nuisance of yourself, as opposed to manifestly unfounded. So the difficulty at the moment, from a practical point of view, my personal opinion, in dealing with data subject access requests and responding to them, is it's very difficult if you've got that individual who, so for example, it comes up a huge amount in employment tribunal situations. So pre-employment tribunals, and in a pre-litigation context, people will make a data subject access request to get access to the data, because there's quite a common misconception that access to data is the same as access to full documents. And so often individuals will think to themselves, right, well, I'll make a data subject access request and that will get me the documents I'm looking for in my tribunal claim at an earlier stage. And the current issue is that to have to prove that a request is manifestly unfounded is really quite difficult. It's a high threshold, whereas the proposal now is to sort of make that easier. So, if someone, so there are a number of factors to look at, which the bill suggests are sort of things that you can consider. We've got to look at it in the round and all the sort of the context of the request, but effectively it will make it easier, because actually you can then refuse or propose to charge a fee, which obviously is something that, again, at the moment isn't possible unless it's manifestly unfounded.
What's the fee, Emily? That's interesting. What's the fee?
So you can charge a reasonable fee. So that exists at the moment, but the proposal is that, so it's basically a lowering of the threshold. So if a request is vexatious or excessive, then you can say, well, we either refuse to respond to it because it's vexatious or excessive, or we will do it, but we'll propose to provide you, we'll charge you a fee for doing so.
Now, to me, Emily, and sorry, you're talking to a geek here. I love this subject. So, to me, as a data controller, refusing a data subject right, does the bill give any indication of what the data controller must do if they are going to use the vexatious, dare I say, vexatious defence about answering the subject access request or charging a fee?
Yes. So. You've got to explain that straight away, but also it's on the data controller to prove the sort of vexatious element, to justify that effectively to the data subject, and if the ICO were to become interested, to the ICO as well.
Cool, excellent. Okay, Kumbi, what are your thoughts on the data subject rights one? Because I see you've got also scientific research and that sort of thing in DSARS. What's your research found us?
Thank you, Nigel. So the first thing is that Emily is perfectly right in the sense that the goal is to make it easier for organizations to decline to comply with the DSAR, or to demand payment in order to comply with it. And the government actually released an impact assessment that they conducted on what the impact of the bill would have if it was passed as is, on the economy and on citizens, essentially. And they specifically highlighted this part to say that the purpose for inserting it in the bill was to make it possible for individuals, to make it not possible for individuals to be able to use DSARs to cause disruption in organizations. So that's a specific, explicit goal of that particular clause in the bill. Now, with regard to how it would work in practice, it would have to work on the basis of judicial interpretation. And that's going to be or guidance by the ICO. But what organizations must bear in mind is that regardless of what threshold is called, what is going to boil down to ultimately is whether or not the refusal to comply would be a violation of that person's rights. That is what any organization is going to have to prove when it chooses not to comply with a DSAR, regardless of what it's called, whether it's manifestly or just vexatious. And at the end of the day, given that the bill is trying to prioritize the ability of individuals to exercise these rights, organizations would be best served not to default to this. Generally speaking, every time someone makes a request that they consider to be, vexatious, unless they are certain that they can prove this beyond reasonable doubt to the ICO in the event that the person makes an appeal to the ICO.
I suppose the other points, just to mention, are that this new threshold, the proposal, is it applies to sort of other rights as well. So not just the right of access. So for example, the right to have your data erased. So it's a threshold that will apply more widely than just Article 15 in terms of access. And I mentioned earlier the sort of factors to consider in terms of working out whether you consider a request to be vexatious or excessive. So it's things like the nature of the request. So for example, something I commonly see is that data subjects, almost to just antagonize their ex-employer, will make a subject access request for a certain amount of data for a set period, and then the next period, and then the next period, and they almost send sort of one weekly. So things like that, the relationship between the data subject and the data controller, the resources available to the controller. So for example, if they're sort of overwhelmed with this enormous request spanning a 10-year period, for example, and they're, you know, a small organization, the extent to which it's a repeat request, but sort of, you know, varied slightly, if there's any overlap, and how long ago previous request was made. So those kinds of things. I don't think it's not a conclusive list, but it's sort of some examples of the kind of things that will be considered.
Yeah, and they're actually quite clear in the guidance from the ICO, and it's quite interesting that FOI and EIR, so the Environmental Information Regulations and Information Act, are quite clearly defined, and that follows quite simply. And Emily, a good example of that I had advising a client a few years ago was that an individual had left the organisation, and they had a long-standing grievance through the grievance procedure against the organisation, and then put in a subject access request in halfway. And then when the individuals through the grievance process, and then when the individual's grievance process was going to be heard, the individual said, "Oh, you can stop the subject access request if you like, and I'll wait to the outcome of the grievance." And I said, "No, we won't." So, you know, there's a good example. That's a good example of someone waiting the outcome of an internal before they decide. And of course, the legislation doesn't define whether you can stop or start a subject access request. So I said, "Well, you'll have to start again." I'm sorry, but to me, that you either carry on or you stop, because it is unreasonable for a controller to stop and start just because you feel like it. You know, you can exercise your rights, but at the end of the day, you can't put an undue burden on the individual. Andrew, just listening to that great conversation, thank you very much, Kumbi and Emily, on that great conversation. That sort of brings me back to Lord Justice Auld in Durham, whereby that actually Lord Justice Auld tried to define the fact of the motive behind the data subject request. Perhaps to me, or what's your thoughts on this, Andrew?
I think there's definitely motive usually instilled in subject access requests. I mean, in employment cases, and in personal injury, in clinical negligence, you will often see people submitting requests, I suppose unnecessarily, because obviously you have the pre-action protocols that allow you to access the information for the purposes of litigation. But I've certainly come across a number of requests in my time where it's very much is motivated. I have seen in previous previous lives gone by that trade unions can also be pretty influential in getting its members to muster together and submit a DSAR, almost as a means of nuisance. So I think there is a balance to be struck here, because by contrast, I've also seen rather overworked and underappreciated medical practices, and particularly GP surgeries, that have received requests who have obviously had to conform with the request, but it's clearly a significant burden to them. But my worry is that lowering that threshold from manifestly, where it's very clearly obvious, to unfounded, does run the risk of interpretation.
Yeah.
And is that interpretation going to be where some GP practices, which are overstretched and overrun at the moment, are they going to turn around and say, "No, we're not doing this because your file's too big"? So I think, I think it's very pertinent. Somebody's obviously mentioned it within the text box here, that the ICO's workload, I think it's Marie, saying that the workload for the ICO is going to go up. And unfortunately, the ICO is already overstretched, under-resourced, and in many cases, under-experienced, because there's a lot of very junior people in there given the salaries and benefits, etc. So I do think that there is a question mark over how this is going to be interpreted and how this will work in practice. And there's also got to be checks and balances here. At the end of the day, data protection is considered to be a human right. Unfortunately, many people don't understand that there's a lot of responsibilities that come with rights, but for most part, there are obligations that sit there. And I think trying to tweak these obligations, which are slightly different to what we're seeing in other countries, such as China and Brazil, who have pretty much replicated GDPR, I do think there is a concern from my perspective here.
Cool. Thank you, Andrew. Thank you. Can we get the next slide, please, Emma? Now I'm going to hand over straight away to Andrew. Andrew, you don't have to go through all of them because I can come back to Cumby, and certainly Emily will have a view on this. But I'm certainly going to go down to 1, 2, 3, 4. I'm going down to bullet point 4 because, ladies and gentlemen, Andrew most probably could be the only person in the country doing a PhD on the role of the data protection officer. I'm not quite sure, Andrew, whether I'm right or not. But Andrew, tell us what you're doing first of all in your PhD, and then certainly talk us through what you believe the senior responsible individual stroke DPO. What does it mean for DPOs on the call today?
Yeah. Okay. So data protection officers are one of the very few occupations where their designation, position, and tasks are inscribed in law. So under Articles 37, 30, and 39 of the GDPR, we are provided detail of the need and expertise of a DPO. The one thing that becomes a bit tricky is the DPO a professional? We think, I'm pretty certain as I've just used that word professional, we'll probably think automatically doctors, lawyers, accountants, possibly architects, and so forth. But is a data protection officer a profession? It's perhaps not a profession in the conventional sense where they are regulated individuals, but is there a need to regulate the role of the DPO insofar as the DPO has to have under Article 37.5 experience, expert knowledge in data protection law, and under Article 38.3 has to demonstrate the role with independence. These are all very high standards, and what I am trying to do is actually determine whether or not there is a gap in acknowledging the DPO as a recognised professional, perhaps without the normal trappings of being a DPO. So that is a whirlwind tour of what is going to be my thesis.
Cool. Thank you, Andrew.
Yeah. Oh, sorry. On you go. Yeah. On you go.
Yeah. So move us on to the proposals within the bill. Yeah.
Yeah. Senior responsible individual. What's changing? In short, not a lot. This is not an opportunity for organizations to turn around and say we don't need a DPO anymore and there's the door. But what it does do is it sets out that the senior responsible individual has to be a senior member of the management team. So no longer just reporting into the most senior members of the organization, they have to be part of it. The one thing that is obvious is the motives of expert knowledge seem to have vanished, which is a bit worrying. And also that there seems to be a bit more of an emphasis that if there is any form of conflict, to ensure that those parts of the role are then provided to a suitably qualified individual. Now, what becomes the delta here is how do you measure suitably qualified when you're not suitably qualified yourself? So I think this is effectively the way I've described it. It's lipstick and pig. Looks like, feels like, and is absolutely the same in many respects, just a change of title. There are some nuances where it is almost played down a little bit. We do see a lot of stripping back of some of the high thresholds that we've seen within GDPR. We've just touched upon them within data subject rights, within the sort of parts of defining personal data and legitimate interest. This is no different. And so ultimately, my view is if you have a DPO in post at the moment, don't think that it's a necessity for you to start thinking that, well, we can replace that individual. And it's also not a get out of jail card, because ultimately somebody still needs to be responsible for data protection, and who better than somebody that's got expert knowledge in data protection. And for those organizations with cross-border aspects, you may actually have obligations elsewhere to have a DPO anyway. So in short, I don't think there is any real difference between a senior responsible individual and a DPO, and it's not an opportunity for organizations to start stripping back and cutting costs, which is often the motive for getting rid of DPOs. And DPOs shouldn't feel that they need to start running off and doing something new to upskill themselves, be that senior responsible individual. You will have the absolute knowledge and expertise to be able to do that thus far, but I do think that it is a change in the way that the person is seen within the organization. They become intrinsically part of the senior management as opposed to reporting into senior management.
Yeah, thank you, Andrew. Now look, Kumbi, you've done a bit of research. You and I have done a bit of research on the proposals. We've got a couple of questions. What about external current organisations such as ours that do? A good example is that the senior responsible individual. I am the DPO at Southwestern Ambulance. We have a senior responsible information asset owner. That person could easily fulfil that task, and the role of the DPO still continues. So I don't see, as Andrew said, a major change in that. But could be, what sort of things have you picked up, particularly around the outsourcing bit, about the opportunities that exist in the bill for organisations and people on the call who might be DPOs themselves, but not part of the organisation? It might be Emily, it might be me. You know, we're good examples of that, actually.
So very quickly, I'll just address what I believe are the options that are open to organizations now. So in practical terms, and someone has already touched on this, Victoria, in the chat section, talking about how C-suite officers are very unlikely to have the expertise to be a DPO. Now, in practical terms, organizations have three options. The first one is to promote their current DPO into the C-suite, board of directors, whatever it is. And that's something that is common practice. In the US, for instance, you see more organizations that have a chief privacy officer who sits in the C-suite along with the chief compliance officer, the chief financial officer, the chief executive officer, and so on and so forth. The second option is to train someone who is currently in the C-suite or board of directors to take on the role of a DPO. But that's impractical. How feasible is it to train the chief financial officer to become the DPO for the organization? So that's not something most organizations are going to be exploring. The last one, which is what I believe most organizations are going to be exploring, is appointing someone, a senior responsible individual, to have operational control and supervision. And that person will then have the responsibility to appoint and delegate the actual duties of performing the role of data protection compliance to other individuals, either within the organization or outside the organization. And that takes me to your question about outsourcing. Now, this is a legal thing now, but the bill uses the words person and individual separately in different places. It specifies that the senior responsible individual must be an individual who is employed by the organization. But then it goes on to say that that person can outsource, can delegate the functions of the DPO to persons. Now, it doesn't stipulate that those persons must be within the organization, which means in practice that those persons can be within or outside the organization. And because it uses the word person as opposed to individual, the legal definition of person encompasses both, human beings as well as corporate organizations, because those
it does, yeah, yes, good spot.
So in summary, there's absolutely nothing stopping an organization from outsourcing its DPO functions to either an individual consultant or a consulting firm. What must happen is that there must be someone on the C-suite or on the board who is going to be directly responsible internally for overseeing the performance of those functions.
Yeah. Emily, what are your thoughts on this one before we cover off the other points? So.
I think my view is I'd like to see DPOs promoted to the board. I think that seems to me the most logical way forward. And it's interesting how I see with clients, sort of particularly really big organizations where the DPO is struggling along on their own, often without a deputy or sort of a wider team to help them. And it's interesting to sort of watch how often, data and the importance of that isn't understood at a senior exec level. And so I think, yeah, that would be certainly my preference. I think that would work well. Obviously, with an external bit, then you could have someone nominally like the CFO, who could sort of take that that label effectively. But I think that would only be really the label, and it would still be hugely helpful for the DPO to be involved at a board level, because I think if you have that, then they're key in terms of decision making and the way in which the business moves forward, because they've always got data in mind. So that would be my view.
Yeah. And Emily, I agree with that. I wrote a paper 2018, 2019, where, for example, public sector organizations appoint non-executive directors who are expert in risk, expert in finance, but actually the data most organizations process is most probably more important and more value to the organization than the buildings they're processing it in terms of the asset value and the potential to move on. Public services, the ability to use data in a legal way to be able to fulfill better public services, organizations to be able to look at how they can produce more goods or ship more goods and the logistics they've actually got. So, I think it's really, really important that a different mindset exists going forward. And Kumbi's exactly right. Chief Privacy Officer, Chief Data Officer. We did a piece of work under data strategy, whereby the Chief Data Officer would be responsible for compliance, i.e. data protection compliance, would be responsible for data governance and also data value, the value of the data they've actually got. So Emily, I think you've hit the nail right on the head there. Now look, I'm just going to say to AJ Holland, I don't know your first name, but don't panic, please. Do not panic. I think there is a role for you going forward. So please don't panic. And look, the bill is currently postponed, and it has to go through several sessions in Parliament before we get to the point. And actually, if you process individuals based in Dublin, in Berlin, if based in Copenhagen, based in South Africa, based in other parts of the world, it is likely you're going to need a DPO anyway. So we're only talking about where data is processed within the United Kingdom at the moment, because those pieces of legislation cannot be swept away by this bill. So Kumbi, could you quickly take us through the other bits of the accountability obligations, please? Yeah, and then Emily and Andrew, jump in when you feel appropriate for any of the points.
Certainly, thank you, Nigel. So the first thing is, with regard to the introduction of the Privacy Program Compliance Framework, is that it fits in with the overarching theme in the bill, which is that it's, according to the government, and I'm quoting directly, it should be outcomes-based and outcomes-focused and risks-based. So instead of having, again, quoting directly, a prescriptive series of compliance measures, the government is aiming for organizations to have the ability to create a custom privacy program where they can decide how much risk they have based on the data they process, and then determine how best to manage those risks and minimize exposure.
It could be. I'm going to stop you there. I'm going to stop you there. But isn't all that's going to happen is the ICO is going to issue a model privacy program compliance framework? So we're going to be in the same place, surely.
Yes, exactly. And it's funny because in some ways, the bill is saying it's reducing compliance burdens, but in other ways, it's hinting that if you don't do it in a certain way, you might have a serious problem. For instance, Article 83 has been expanded to say that in the event that an organization chooses not to consult with the ICO, after having done a DPR, a data protection impact assessment, and discovered that there are still high risks, and they choose not to consult the ICO because it's now optional, that Article 83 covers fines. The bill now says that refusal to consult the ICO will be taken into consideration when fines are being determined. So it's sort of, you have flexibility, but you have to bear in mind that, you might get hit with a bigger fine if you don't do it exactly this way. So in practice, it doesn't seem it's going to change much. But just moving on quickly to the issue of the ROPA, that's the first major change, and that's removing the requirement in Article 30 that organizations must have a record of processing activities, and the UK GDPR currently lists the elements that must be present there. The funny thing is, the bill removes the name, record of processing activities, and replaces it with appropriate records of processing of personal data. Now, I'm going to leave it up to
Not made in
everyone
London can be. That's
to
not made.
determine,
That's a made in London statement. The ROPA is a
determine-
not made in London statement. Yeah.
yeah, to determine how much of an impact that's going to have. But in practice, again, the new Article 30 stipulates contents that the new appropriate records must contain. The only thing that it does is it now makes the inclusion of security measures optional. But again, in practice, there would be absolutely no point in building out a ROPA and then just omitting the sections that deal with security measures, because ROPA is important not just for compliance when you need to show the ICO, but also for your organization when you need to track something, extract information for a subject access request or some other things like that. So again, in practice, it seems it's much the same thing, just under a different name.
And of course, we must remember, Cumbri, that if we are developing a record of processing, let's not call it a Article 30 record of processing activity, let's call it a record of the personal data that we process. You're not going to have two of them, are you, for those that you offshore and those that you maintain within the UK, are you? You're not going to have that.
Exactly. So it makes sense. And you said this earlier, it makes sense for most organizations simply, and Andrew said this as well, it makes sense for most organizations simply to maintain a ROPA that contains comprehensive information that the GDPR currently requires, such that if they need to prove compliance to the ICO in the UK, they can simply present them with the ROPA, and the ICO can take whatever information they need from that. And if they need to comply with the CNIL in France, for instance, they can simply present them with their ROPA, and that organization can take out the information it needs to verify their compliance.
Okay,
So,
let me just bring in Andrew and Emily. What are your thoughts? And Teresa, you've asked the question, is an information asset register too? Isn't it? No, an information asset register contains all the information that an organization process. This is only a requirement to have a register of personal data. So where you process personal data, there is a requirement. An information asset register is broader. It might have details about vehicle maintenance. It might have details around financial information and those sort of things. So yeah, it sometimes looks the same, and it contains some of the same information, but actually the legislative requirement is only for where you process personal data. Yeah. So Andrew, what's your view? And then Emily on the
yeah. Well, I'm actually quite keen to look at the next point, which I'll come on to in just a second. But I mean, ROPA, the amount of organizations I've come across that still don't have one. This is, we're a few years on now, and there's a lot more organizations that struggle to get to grips with this stuff. An information asset register is obviously something that's more of a nice to have, and actually helps build that contextual sort of picture, such as doing some mapping of systems and how all your data flows work. ROPA is obviously it's useful when it comes to points when you might have suffered a data breach and not quite sure the what, the why, the where, the how, the when. So it usually does help fill in the blanks. And I'm just going to touch on very quickly the DPIA point. And if you think about what I've just said with regards to ROPA, and then think about the purpose of a DPIA to identify risks, I go back to my point. What is risk-based approach? It's completely ludicrous to remove two items that absolutely support your risk mitigation planning, and yet the law's proposal is to remove it. I leave you with that thought. Over to Emily.
Of course, Andrew. And of course, Andrew, you're only talking about where you process personal data in the UK. The minute you process personal data with someone in Bay Air, where I was.
Well, I will come on to James's point. I noticed that he has mentioned something. I know in the next slide we'll be talking about other things, and I'll bring that up there.
Yeah, Emily, what are your thoughts on the on this slide here? Yeah.
Yeah, I think that's the biggest thing for me, isn't it? And it's the biggest thing that clients will ask is, well, what does that look like on a practical basis? What do we actually have to change? And I think I would be, as a litigator, very much in favour of keeping a good record for accountability purposes. So I think I would still encourage clients, if they've got comprehensive things in place and they're already happy with their DPIA system, unless it's really sort of overwhelming or something that they could, they need resource elsewhere, then I'd probably just encourage clients to sort of carry on what they're doing, because I don't think it hurts to have a really comprehensive set of record keeping in place. That said, I do know clients where DPIAs are hugely time intensive across the business, and they're doing them for absolutely everything, even when, in my view, they don't need to do them, but they do them and they follow the whole process in order to discover that there actually isn't any risk to this particular exercise. So I can see the intention behind you only have to assess the high risk processing. But I suppose it's just practically speaking how you can kind of get clients to that level of saying, okay, well, these are the kind of activities we're doing, and let's just be able to sort of section these ones off as high risk, and then we'll very much do assessments of those. So I think that will be part of the challenge for clients, is understanding and getting some guidance from us as advisors as to how to sort of hone in on the ones which, and as Andrew said, because who gives the definition of what's risky and or not, but how to hone in on the ones that they should be focusing on. And I think in bigger organizations there might be a reluctance to sort of be too bold about these are our only high risk ones and the others aren't a problem. And so that will be a difficult kind of level for businesses to put in as well. So interesting times.
Yeah, one thing I always try and remind, when I'm teaching, I always try and remind data controller is that a data protection impact and assessment is really a twofold tool. The legal requirement really is to assess the high risk of the data subjects. So that's the starting point. So if you've got nothing to assess the high risk of the data subjects, then you're on a sticky wicket as we start. But the second thing is that surely a data protection impact assessment then goes forward then to assess the safeguards that you've got, the Article 32 safeguards you've got, your organizational, physical, technical measures that you've got to ensure that the new piece of software, the merging of databases, the contracting third-party supplier that you are now contracting meet the obligations of maintaining individual rights, but also keep their data safe. So it's a twofold tool. And I don't think that principle is taken away by the bill. So I agree with Emily, and some organizations and certainly Andrew's point and Kumbi's point was actually that you might as well continue data protection impact assessments because they do those twofold activities, one of which sets the risk to the data subject, and two, it also assesses the security that you're going to have around that business change. And that's really important.
I think some of it at the moment is driven by the software that organizations buy to help them with their data protection. So for example, OneTrust, if you have got a DPIA system in place, you're rather driven by the pages of forms that the OneTrust system encourages you to fill out as part of your DPIA. So I think it'll be interesting to see how those flex, because then the clients will flex with them in terms of a lessening of requirements, or perhaps something that OneTrust, for example, or other software providers might put in place to say, okay, well, this is a new bit that we've added to the software in terms of what used to be called DPIAs, which helps you consider these certain factors to work out which are your high risk processing activities, and then you only need to fill in your DPIAs for some of the processing activities. But I think because there's quite a reliance by big clients in particular of mine on that kind of software to help them facilitate that, because otherwise it's a bit difficult to sort of put that kind of the record keeping and things in place, then they will need adjustments to that software to sort of help them flex to the new system.
Absolutely. I'm just going to push this along a bit. We've got a couple more slides. And Rachel, you make a good point about the fact that you're going to have to run dual compliance program. Can we just go back to the last slide, Emma? There are a couple of other points. A couple of other points that we should cover. The removal of the requirement to appoint a UK representative. Well, that's if you're a third country and you're processing personal data in the UK, you don't have to appoint a UK representative. I have to say, these are few and far between, UK representative. I do know of one. The other thing is that if you're a third country and processing personal data in Dublin, you still have to appoint an EU representative. Think about it. And then the changeover threshold of risk assessment international transfer will bring us on to the next slide, please, Kumbi. So can you take us through quickly international data transfers, please?
Certainly. So here, the major change is in removing the obligation that organizations have, or reducing the threshold that organizations have to meet in terms of being able to determine, again, that risk-based approach that Andrew has spoken about comes into play, to determine whether or not it's high risk to transfer personal data to a third country. Now, the bill says that organizations are going to have to conduct a data protection test. In the EU, the operative mechanism now is sort of a transfer impact assessment under the GDPR, sort of on the basis of judicial decisions that had determined that certain frameworks like Safe Harbor, like Privacy Shield, were not sufficient, meaning that now organizations are going to have to conduct these same tests, but the standard for that test is no longer going to be as had been determined under previous judicial decisions, which is that it should be essentially equivalent. Now it's going to be that it should not be materially lower. Again, it just goes to the risk-based approach, because you're still going to have to justify how you came to the decision that a third country to which you're intending to transfer personal data does not have, materially lower data protection, a materially lower data protection framework. So it's still something you're going to have to justify on a case-by-case basis. So that assessment is going to have to continue to take place on a case-by-case basis. But the more crucial aspect here is in the forward-looking aspects of international data transfers, which is where the bill is saying that the Secretary of State is going to now be able to.
Now, which Secretary of State? Who have they given the decision-making to? Is it DCMS?
The Secretary of State. It just says Secretary of State.
Okay, which DCMS, I guess, then, yeah, okay,
yeah. It's going to be able to make decisions on adequacy as to which countries are going to be determined to be safe, that organizations can automatically, in quote again, transfer data to without needing to go through the tests of determining whether or not that transfer is going to constitute a high risk to the data subjects. Now, crucially here, and this is more, a political and legal thing, a priority for the government is that the United States should be, fed into this mechanism where the Secretary of State can determine the US as being an adequate country. And a number of problems exist with that. The first one, from the perspective of the data subject, is that the US has a, shall I say, questionable reputation with regard to its, habits, practices of infringing on privacy. But more crucially for organizations is that an attempt to make the US an adequate country would then place the UK in a position where it's serving as a transit location for personal data from the EU through to countries that the EU itself has determined to not have adequate protections. And that would then raise concerns on the UK's own adequacy status with the EU. So ultimately, again, it's a political decision. It will boil down to whether the government prioritizes the transfer of data through with the US or with the EU. But ultimately, the law is changing and it's going to allow some more political intervention in determining adequacy status.
No, the government have altered the arrangements, and by March 2024, transfer TIAs need to be in place for organizations that transfer data from the UK to third countries. And, India is a good example, by 2024. Is the intention that the data protection test replaces the current transfer impact assessment?
Yes, that is my assessment. It's going to replace it, not in the sense of changing the actual test that needs to take place in terms of the actual admin, decision-making process, the assessment, what you evaluate in terms of, because currently when we, at DPAS, for instance, conduct a transfer impact assessment, we're looking at the laws in the country to which the client is proposing to transfer data. We're looking at, the judicial history of that country. How effective is the remedial process for people who believe their privacy rights have been violated? We're looking at other things that might not feature within any of those, but might give us a hint as to how much that country respects privacy rights. So ultimately, in this new test, organizations are going to have to consider the same factors. As a matter of fact, they're also listed there. The only difference is that the threshold is being amended, so to speak, to now reflect that it's not materially.
Understood. Thanks, Gooding. Andrew, you had a point, didn't you? You wanted to make on international data transfer. So.
Yeah, I've lots of points to make on this. I mean, notwithstanding, the Department for International Trade estimates that the UK has exported 190.3 billion digitally delivered services, which works out about 67.1% of total UK service exports. When you think about that and you think about international transfers, it becomes quite interesting when you see, and I'm sure, Emily, you've come across this yourself, when you come across data protection agreements that are just rhyming chapter and verse of what the regulation says. Now, the regulation is static. It's not going to change. You have obligations therein. It's not necessary for those obligations to be set out word for word within a contract, because those are not going to change. I have seen examples of where organizations where there's multi-jurisdictional aspects to this, that they start bringing in everywhere. So I've had one recently that quoted PIPL in China, LGPD in Brazil, the Federal Privacy Act of 1988 in Australia, the EU GDPR, the UK GDPR, UK DPA, and it's just an absolute shambolic mess. What I want to say on this, though, is there's no need for organizations in many respects to have multiple compliance streams existing to comply with data protection law. My advice, and the best way to operate, is take the highest possible threshold and caveat around it. So if there's specific caveats within the California Consumer Privacy Act, which there is with regards to how data subjects are able to put in requests, for example, then you build that into a model that might be GDPR. Certainly in my previous role, we called it GDPR plus. If you were operating in the likes of South Korea, I would probably say that you would use the South Korean model as the highest threshold, because it is one of the most robust data protection laws in the world, so much so you probably wouldn't want to be a data protection officer over there. If you get it wrong, you go to jail. So ultimately, I think with bringing it back into the bill, I think that there's actually probably a wider issue in terms of international data transfers. We live in a very digitally motivated world, and we all push a button without thinking really where it goes, how it works, and what the impacts could be if it goes wrong. And we just assume that everything will work. So from my perspective, the bill doesn't necessarily provide any form of real clarity on the wider international data transfers piece. And in fact, I think it's very pertinent within the chat box that all it seems to be is a change of terms and dulling down. And we mentioned this at the very start. The bill is on hold at the moment. It is very possible that this bill, probably more politically motivated rather than motivated by principle of law, i.e. Brexit, I think for all of those types of burdens that people are perhaps thinking about, the status quo is think about the highest threshold that you need to comply with and why you need to comply with that, and then adopt that model, because it's not going to be any worse than what's been presented by the UK government. And in fact, there's a question mark over whether or not the UK will remain a country of adequacy beyond this, given how much they have decided to dull the law down. So that's all I wanted to say on that.
Thanks, Andrew. Emily, any points on international data transfer? I know you have to go at 12, so by all means, thank you very much for your input. We won't be going too far over 12, so yeah. So,
no, a pleasure. No, nothing else to add. That was perfectly summarised.
Thank you, and Emily, thank you very much for your input today. That's really helpful. Thank you very much, and we'll catch up soon. So yeah, cool. So the next couple of slides we'll briefly scan over. Let's go to cookies and direct marketing. Look, we have a legislation at the moment, the Personal Electronic Communications Regulation 2003. It sits alongside GDPR, and it's a flipping mess. You have small to medium enterprises trying to apply 2 different pieces of legislation for the same activity. It's crazy. So in some respect, I'm very keen to see tech regulations to be abolished and enshrined within one act, so that the small to medium enterprises and people who are trying to work within the legislation are able to do so without consulting 2 pieces of law, because they're running a business after all, selling retail goods rather than necessarily engaging lawyers. Now, Kumbi, is it going to do that for me? Is the bill doing that? What's it going to do around cookies and direct marketing? Is it going to stop the annoying pop-ups every time I go onto a website and I want to book my train ticket, but it's the same thing that I saw last week and it's the same thing that I see every single time I go on? What's it going to do for me, Kumbi?
So no, I'm sorry to disappoint, but no, it's not going to stop the pop-ups, right? Not straight away, but eventually, the government has said the goal eventually is to make cookie control a more centralized approach to it. So it's going to be controlled from your browser, so you can set your cookie decisions from your browser. An organization and websites are going to just adopt whatever it is you've set on your browser eventually. But for now, the only change to cookies is that these cookies that are listed here are going to be able to be placed without user consent. So you still get a cookie banner, just that there will be fewer choices for you to select your cookies from, so to speak. Now, the other change...
you've made my day, you've made my day.
The other changes are that, and the first one and the last one tying together, because the government has said, the ICO has said in its latest strategy update that it made to the public, that one of its priorities was ensuring that you no longer have the sort of direct marketing violations that we currently see, especially those that are targeted at vulnerable people and are targeted at being used to abuse people and the like. So it's stated there, and that is why they've increased the maximum fine amount in the PECR from £500,000 up to the same standard that is in the GDPR, which is £17.5 million, or 4% of the organization's turnover. Upstairs. Now, the last one is with regard to the soft opt-in rule, and that relates to the ability of organizations that are not commercial organizations to use the same soft opt-in rule that exists and is available to commercial organizations. Because now an organization can send direct marketing if someone has purchased from them in the past. But now it's also going to be open to non-commercial organizations, such as NGOs, for instance, your church, your political parties, to reach out to people who have engaged with them in the past in order to be able to solicit something from them, or it's all in the sense of trying to encourage these organizations to be able to use the data they have to promote their operations.
Cool. And Emily, anything quick on cookies and direct marketing?
I just add quickly before I head off. So I am starting to see a lot of cookie claims. So I think it might be the latest thing after sort of data breach, small data breaches. And I was just reflecting, actually, sort of listening to Kumbe there. So the key interest for me is the extent to which the intention for the commissioner to sort of publish guidance about what fines and things will look like in terms of cookies, and how they're going to put penalty notices and enforcement notices and things in place is of interest to me, because I'm seeing a lot of claims in terms of breach of the PEC regs, because you haven't been clear about what cookie information, and you didn't have my consent, and something somewhere has gone wrong in the client sort of system in terms of cookies. And the key sort of complaint seems to be around tracking and passing information, so sort of Google and Amazon via sort of advertising and things on the site. And I didn't allow you to do that. I didn't give any consent that cookies could be placed in that respect. And so that's not covered off at all in the bill, as far as I can see. And that's something that is becoming a big consumer issue in terms of cookies for them, in terms of keeping control of their personal data. And so for me, I'd like to see the extent to which the commissioner is going to include any guidance around that.
And of course, the challenge we've got, Emily, the challenge we've got also with cookies is and in fact is access to websites. Is anyone anywhere in the world can access your website.
Yeah.
So
Yeah.
this once again goes back. I can't remember who just said it. I can't remember who just said it on the chat box, but actually it's about the dual compliance that you're going to have, isn't it? It's crazy. Yeah, it's crazy. Yeah.
Yeah.
Emily, thank you very much.
Thanks very much.
Andrew.
Thanks all. Have a good rest
Bye-bye.
of day. Bye.
Bye. Andrew, anything on cookies and direct marketing?
Yeah, I suppose for me, I find it quite strange that there's nothing mentioned, and yet we also have, and we'd be loath to forget, the online safety bill going through as well, which again is silent on cookies. It's interesting, isn't it, that something that actually something that probably be good to discuss with Emily on a lawyer to lawyer basis is that point on claims, because ultimately I think even with the data breach thing, there's definitely a lot of claim companies out there that are willing to do the no win no fee and small claims. I think there needs to be a bit more clarity on what's expected of organizations here and what is best practice, because I think for a lot of people, or certainly my experience is, a lot of people are just fudging it, doing what they think is right and drafting a policy that looks right, but are they actually attesting to it? And a lot of this is about demonstrating the compliance, and demonstrating compliance is not just putting in a policy, it's measuring the effectiveness of those policies as well. So I think there's a huge gap here and
Cool.
Really disappointing.
Thanks, Andrew. Next slide, please. Really helpful. I'll talk through the role of the ICO. Look, I think that I concur with Andrew and Emily from our organisation. We are supporting a number of clients through claims against hacker, whether that be opt-in marketing, whether that be consensual, whether that be cookies. And I do say to our data controllers on the line today and on the webinar today, is you might want to go back and look at your strategy. There is a round robin going round of how to do it. And as Andrew has quite rightly said, most of these claims end up by being paid off before they ever get to, or go to the small claims court, and you never get a judicial statement on what good looks like, or what a trivial claim looks like. So be aware, there are people making good money at the moment, I'm afraid to say, through claims around as such. So any clarity that government can give, I think, would be really helpful. So the final big slide we've got of the day really is the role of the ICO. Remember what I said earlier part of the early part of the webinar about what the previous data protection register said in the early 80s about the powers that were given to the Information Commissioner as such. So the role of the Information Commissioner is introduction of new investigatory powers, and that's just in alignment with the investigatory powers that every other regulator has. So at the moment, there are broad regulatory powers that the ICO has, but they're actually deepening them to ensure that they've got the same powers, for example, as HMRC and those sort of things. So that's no different that you would expect them to have. A change of corporate structure to enable the board to be accountable to the Secretary of State, where we heard that before. So the independence really of the Information Commissioner is really now being stripped away, and the Information Commissioner now will report to the Secretary of State. So in essence, it's an attempt to, I think it's fair to say, by the government to put controls around what the information controller's policy might be and their strategy might be going forward as such. And ultimately, you can see the Secretary of State is wielding powers. Now, that actually brings me to, yes, without doubt, Rosie, you're right. That then ultimately brings to, does the Information Commissioner sit properly within the Department of Culture, Media and Sport? Because if the government's intention of the Data Protection and Digital Information Bill is to unleash the power of data and reduce the burden on business, now would it not best be sitting in the Department of Business and Enterprise and Skills? Because surely that's where growing business actually sits. So So I think it's a fundamental question, and funny enough, it was a question that that I raised to my local MP a couple of weeks ago when I saw him, and he said, "Yeah, that's a really good point you make about the bill. It is actually that that does it actually sit within the right department?" But yes, Rosie, I think you're right. I think that there is a move to bring it under political control, which will therefore aid decision making and also meet the government's agenda to be able to move this forward. But this is no different than most other regulators we've seen, I have to say. So I'm not, you know, I wouldn't necessarily see that as a bad thing as such, but certainly it's one to watch out for. It depends on what the. But I can assure you, Rosie, from my perspective, I'm almost sure that it's about the Information Commissioner focusing on growing business rather than regulation, and reducing the burden on. But I'm afraid to say, and Kumbi, I'm going to leave you with the final word on the slides. Do you think, from what you see, you know, you're a lawyer in Nigeria, and you've come and studied in the UK. You've got a master's in law. You're a fairly bright guy. Have you detected that the bill will achieve the government's aim of creating growth and reducing burden? And Andrew, you can answer the question next. I'll ask you to follow on from that.
Thank you, Nigel. So, to be honest, I think, yes, it will achieve the aim of boosting economic growth. The thing, though, is that it will have the opposite effect on people's rights. So that's the crucial, you know, factor that everyone has to bear in mind. If the goal is to make it possible for businesses to use data with little or no, you know, consequences, then the bill goes some way to achieving that. You know, as we analyzed earlier, in reality, many of these compliance obligations are going to remain the same. But the flexibility it gives to businesses is going to have the effect ultimately of reducing the ability of data subjects to exercise their rights, to ensure that their data is not being abused, to ensure that the data is not being used for, you know, economic development that will not benefit them. Because, you know, the whole discussion about exempting scientific research from the obligations for transparency in Articles 13 and 14, for instance, doesn't specify exactly what falls into scientific research. So a private company might take your personal data, use it to develop their products and services, and, you know, you get no compensation for that. And, you know, that product and service is still something that you're going to have to buy at full price at the end of the day with, you know, little or no benefit to you. So ultimately, yes, to an extent, but also it has a seriously deleterious effect, as Andrew mentioned in the context of the HAMS bill, on data subject rights.
Thank you very much, Kumbi. Andrew, sort of your wrap-up comments, really.
Really interesting point. Does the bill and the weakening of the ICO role not move us further down the road of data protection by litigation rather than by law, or I assume by statute is what's being referred there, Marie? But yes, I'm inclined to agree. Judges are eventually going to have to start doing a little bit more in this field. And to be fair, I think I think the actual sort of case law aspect and litigation that currently exists for this is actually relatively limited, which is perhaps a good thing in many ways, because it means then it's relatively well understood by both organizations and by individuals. Does diluting it then increase the risk of litigation? Probably. So I think that the bill, whether the bill actually then proceeds, I mean, is Liz Truss going to be quite as, because my view of the bill, very critical or critically, is it's like a child that's thrown a dummy out of a pram. We've left the EU, so we must be different. And it's no different. And if you start following what they've tried to produce, I think it's just causing more confusion unnecessarily, and realistically, it's just an opportunity to be seen to drive economic growth. Will it actually result in economic growth? Well, I mean, I think there's other challenges that might curtail economic growth at the moment, but I do think it obviously loosens some of the burdens on organizations. Organizational obligations in this field are particularly high when you compare it to some other areas that are, again, deemed as, and I know that obviously there is legislative sort of movements in human rights, but when you compare it to other areas of human rights, organizational obligations in this field may be deemed to be quite stringent. Is it necessary? In some cases, and what I've seen, yes. In other cases, no. And striking a balance is really difficult, particularly when we start using terms like reasonable, proportionate, risk-based approach. All of these terms mean absolutely zero and nothing. So ultimately, I think it's a watch this space. Don't rock the apple cart too much. Don't start thinking that things need to change dramatically overnight. Stick with the status quo for the time being. Let's ride out the storm and see what comes out of this, because John Edwards is going to have one hell of a job on his hands.
Andrew, thank you very much. Thank you very much for Emma, if you go to the next slide, yeah. Thank you very much for everyone coming along. It's been really informative. Andrew's comments were refreshing, and Kumbu's comments were refreshing. Remember my phrase, made in London, not made in Europe. I think there's some semantics here with the bill. And there will certainly, in my opinion, and this is only my opinion, be a number of changes if the legislation does come back to Parliament. As Andrew quite rightly said, we don't know whether legislation will come back to Parliament in its same form, because we had the online safety bill at the same time. We had the government just gone out to consultation, by the way. If you follow me on LinkedIn, you'll see there is a piece of consultation taking place around defining what safeguards, information security and cybersecurity safeguards, and what good looks like in terms of organisation. So the government might come back with a refined bill, a data protection bill, which actually lists the type of safety and security that you might need, like Cyber Essential, Cyber Security, Cyber Essential Plus, and these sort of things. So there's a lot going on in the GCMS at the moment. We've got a new minister. I'm really intrigued to see what the outcome will be. We've got a couple more webinars. We've got recruitment and data protection in October. Subject access request is always a good one. And then November, I won't be doing that. Applying data protection to marketing activities is certainly not my area of expertise, but thank you very much for coming. We will be sending out a feedback form, because we like to get our feedback for this, as that's okay. Thank you very much, everyone. Really appreciate, and have a really super day. And what we will do, everyone on the call, is the minute we find out whether the bill comes back to Parliament and what changes have been made, we promise we'll run another webinar just for the differences. Andrew, thank you very much. Kumbu, thank you very much. Have a great day, everyone. Thank you.